I'm Rajiv Haté. I'm a senior litigation specialist at Kotak Personal Injury and Disability Law. I have been with the firm since 2017, and I take pride in representing people that are injured or disabled and are unable to work or have suffered an injury due to the negligence of another. I understand the importance of moving files expeditiously. Our clients require that files are moved in a quick and expeditious manner. And I also really pride myself on the importance of regular communication with clients. I have previously worked on the defense side of things, where I used to represent insurance companies, and I think that gives me a broader perspective in terms of how cases are handled and the thought process that goes behind both how a plaintiff may handle a case and how the defendant may handle the case. Today, I'd like to answer a very common question that we get here at Kotak Law with respect to what the process is about applying for disability benefits. Typically, if you are suffering from an injury or an illness that prevents you from working, of course, the first step is seek medical advice. Speak to your doctors, and if your doctors agree that you need to take some time off of work, determine if you have any disability benefits available to you. The most common is through group policies offered by your employer. If you have a group policy offered through your employer, first check, do you have short-term disability benefits available to you? And if not, if you have long-term disability benefits available. If you do have short-term disability benefits, then you should apply for that first, as that is the first stage. And applying for that requires you to complete a statement, essentially detailing your disability, when it started, when it prevented you from working, what the illness is, what your symptoms are, and why it prevents you from being able to perform the duties of your job. Your doctor will also have to complete a statement, usually known as an attending physician statement, also detailing from a medical perspective what your diagnosis or diagnoses are, as well as your symptoms, and of course supporting when it prevented you from working. Often your doctor is asked about the prognosis with respect to how long it may require for you to recover from your illness. That is something that, of course, you can speak to the doctor about. And one thing to be mindful of is that anytime doctors write, they expect you to have a recovery in a short period of time, disability insurers will rely on that and often use that to deny claims. So one thing that I always suggest to clients when they are applying for disability claims is, when speaking with your doctor, if the prognosis is truly unknown, which most of the time it is, because most of the time you have to get treatment first, perhaps ask the doctor to reflect that in the statement that they provide to the insurance company. The last important element of applying for disability claims is an employer statement. That's something you'd have to speak to your employer about completing, and if it's a group policy through your employer, that's something they likely do regularly, probably through your human resources department. If you do not have short-term disability benefits available to you, often what employers say is that you apply for EI, unemployment insurance benefits. Usually you would select a sickness or disability option, because that's of course the reason you're not working. And then following that is when you would apply for long-term disability benefits. I always suggest either way apply for either short-term or long-term disability benefits right away. Even if there is a waiting period before you may be eligible to receive the benefits, it's better to get the process started. And often, most insurance policies contain provisions that say you are required to apply within a certain period of time. And if you do not do so, sometimes it can even result in a denial of your claim on that basis alone, or it will just invite questions in terms of why was there a delay in applying. Again, might as well avoid those questions and just apply as soon as you know that you're incapable of working because of an illness or injury. Once you have started the application process, if it is whether it's a short-term or long-term disability claim, there is often an initial telephone interview that takes place. During the telephone interview, the insurance company will ask you questions about your illness, when it started, what your symptoms are, when it prevented you from working, and why it's prevented you from working. There are very important elements to understand about this phone call. Insurance companies go into numerous details, including what are your functional restrictions and limitations. In addition to that, they will ask about what are you able to do in your personal life, either socially or recreationally, or in terms of your housekeeping abilities. I'm going to speak about both. With respect to your functional restrictions and limitations, the reason that is important is because almost every disability policy, the test for being totally disabled, is about whether you are functionally capable of performing the duties of your occupation. That is usually the test during the short-term disability period, as well as an initial period for long-term disability benefits, which I will get into shortly later in terms of when that test changes. The point to understand is that when the question is about are you functionally capable of performing the duties of your job, it is about what are the restrictions and limitations that affect your ability to perform your job duties. A lot of policies, in fact, say it is not about the availability of work and it is not about workplace issues with an employer. If you can perform those same duties at home or elsewhere, for example, at another job or at a different location or even in a different department with your own employer, the insurer will argue you do not meet the disability test. And so it is important to focus on what prevents you from doing the duties of your job. The other thing I mentioned is that during the initial telephone interview or even in other phone calls throughout the assessment of your claim, often disability insurers will ask, what are you able to do at home? Can you do your social and recreational tasks like you used to, going out with friends, family, whether it be, going to the gym, going to the movies, whatever you used to do on a regular basis, are you still able to do those things? Similarly, they will ask about your ability to complete housekeeping tasks at home. They'll ask, what were you doing beforehand? Cooking, cleaning, grocery shopping, laundry, outdoor work, such as cutting the grass or shoveling the snow, things of that nature. And if you are still doing similar tasks to what you were doing after your disability started, they will question, whether it be from a housekeeping perspective or from the social and recreational perspective, how is it that you're capable of completing those tasks, but you're not able to work? And so my suggestion is to always be mindful of your answers. The average person will hear those questions and answer it honestly and truthfully, which you should. It is important to be honest and truthful with insurance companies. However, don't downplay your impairments. If your impairments are also affecting your ability to complete those social, recreational, or housekeeping tasks, which insurance companies often combine and refer to as activities of daily living, then make that very clear to them that it does impact your ability to complete those tasks as well. I mentioned just now about being truthful and honest with insurance companies. That is extremely important because we are often asked questions with respect to do insurance companies arrange for surveillance? And the answer is yes, they do. They don't do it in every case, and even when they do arrange for surveillance, the private investigators that they hire are good at their jobs. You likely will not even know that they're there. The point is, be mindful that they will potentially hire someone to follow you around personally, or even conduct investigation online. For example, searching social media, whether it be Instagram, Facebook, Twitter, even LinkedIn. They will look at what you are posting and what you are reporting. It's very common that when you are posting things on social media, you post happy things. And so that is when insurers will potentially use that against you to say, well, you're telling us you have an illness and you're not doing well in your life, but here you are posting pictures of being out or showing as if you're happy, and they'll allege that there are inconsistencies there. It'll start giving them reason to question your credibility. My suggestion in that respect is keep your social media profiles on private. Don't allow them to access it unless they have to friend you. And also be mindful of what you post and what you're doing. With respect to if they have a private investigator following you around, I always tell my clients and potential clients that as long as you are not doing anything that's outside of what you've told the insurance company you are not capable of doing, then you have nothing to worry about. The point is, if you say you have restrictions and limitations, or for example, I don't go grocery shopping anymore, or when I go, I'm only there for a short period of time and I'm not carrying heavy items, as an example. If you're going and doing just that, you have nothing to worry about. The concern is when you tell them, I can't carry heavy items, and then they see you carrying cases of water or something that would be arguably heavy. That's when, again, they start to allege there's inconsistencies and they'll start questioning your credibility. Now, another very common question we are asked is with respect to, should you participate in a rehabilitation program or a return to work program? So the short answer to that is yes, in the sense that every policy often contains requirements that you are obligated to participate in such programs if the insurance company asks you to do so. And if you refuse to do so, they will argue you are in non-compliance with the policy. The insurer will potentially then deny your claim on that basis alone. And at that stage, the denial of your claim is not necessarily based on the merits of your illness, but rather you being non-compliant with the policy provisions. The caveat to that is, if you believe that participating in a return to work program may negatively affect your current illness, where it may exacerbate your impairments, you should speak to your doctor about whether or not it is appropriate for you to participate in the program. And I suggest that's the first thing you should do in any event. Tell the insurer, well, before I agree to this, I'd like to just run it by my doctors, my medical practitioners, my specialists. If you're seeing a psychologist or a psychiatrist or a rheumatologist, whatever it may be, run it by them, as well as your family doctor. And if your doctors agree that participation in such a program could adversely affect your impairments and could in fact cause a setback in your recovery and would not be conducive to you recovering from your illness, then you should inform the insurance company about that. Ask your medical practitioner to provide you with a note confirming that. And on that basis then, if you refuse to participate in it, you would be doing so by following medical advice. Now, the one thing to be mindful is that if that happens, the insurance company may then reach out to your doctor or medical practitioner directly, whether by phone call or by way of a letter, asking them, what are the contraindications to you participating in such a return to work or rehabilitation program. And therefore, if your doctor is going to support that you should not be doing it, give your doctor a heads up that the insurance company may contact them. And of course, the hope would be that whatever the doctor responds to the insurance company, it's going to be consistent with what they've said to you and what you're going to be telling the insurance company, and potentially any note you've provided them with from your doctor. Another very common question that we are asked here at Kotak Law is about the change of definition date in long-term disability policies. Almost every group long-term disability policy contains what is referred to as a change of definition date. What that means is the test for total disability changes from whether you are capable of performing the essential duties of your own occupation to, are you capable of performing the essential duties of any occupation based on your education, training, and experience. The majority of group long-term disability policies have the total disability test as whether you can perform the duties of your own occupation, meaning your own job, for the first 2 years. I've seen some policies where it's as short as 6 months or even 1 year. Every policy is different, and that's something you should check your policy to see how long that period is. The change of definition often occurs at that either 6 month, 1 year, or 2 year mark. The most common is 2 years. And at that point, the test is now, can you perform the duties of any job, essentially? It is based on your education, training, and experience, but that is where it is a more difficult test to meet. And that is the point where a lot of insurance companies deny even legitimate claims, because they will allege that you are capable of performing some alternative occupation. Often what they do is get a medical opinion, sometimes from an internal medical consultant, someone that's never seen you, spoken to you, or even treated you, to give an assessment of your condition just based on the records they have in their file. I always suggest, again, speak to your own doctor about that and see if your own doctors will support you're incapable of performing any occupation based on your illness. The important aspect there is that your doctors don't have to say you'll never be able to work again, but that because of what you're currently going through at this point in time, you're not capable of doing any other job. Usually when doctors support you cannot do your own job, most of the time those impairments would prevent you from doing any job. For example, a lot of my clients suffer from illnesses where it affects their cognitive abilities. They can't focus, they can't concentrate, their memory is impaired, or they cannot sit, stand, or walk for prolonged periods of times, or they're in so much pain that they lose attention and focus. And quite frankly, if that impacts you to do your own job, you have to think about what job could you do where that wouldn't be impacted. Of course, you'll need medical support for that, but it's something to keep in mind as you are approaching that change of definition date. Now, insurance companies will also rely on what you say in that regard. Again, if you say that you may be capable of performing some other duties or some other task, or maybe, for example, you would need modified duties or modified hours, you could work part-time now, they will then use that to allege, and especially if you show an ability to do those tasks, they will say, look, if you could work part-time or modified hours or do modified duties or work in a different department, well then that means you are not meeting the total disability test of being incapable of performing any occupation because you've now demonstrated the ability to perform some other job. Of course, the important thing is to follow your medical advice and listen to what your doctors say, but these are very common elements and stages of disability claims that you should be aware of if you are in the middle of a long-term disability claim. Now, with respect to the change of definition date, there is also something known as CPP disability benefits. I mention that with respect to the change of definition date because that is often the time when insurance companies may ask you to apply for it. A lot of group long-term disability policies say that you are required to apply for CPP disability benefits, and if you do not apply, the insurance company can estimate the amount of what you may be entitled to and deduct it from what they pay you. However, when the disability test is, can you do your own job, off for that first, commonly 2-year period, often disability insurers do not ask you to apply for CPP disability benefits. Instead, they start asking as you're approaching that 2-year mark or that change of definition date where the test changes to can you do any job. And the reason is because through CPP disability benefits, it is through the Canada Pension Plan, through Service Canada, the test for being disabled for a CPP disability claim is, do you have a severe and prolonged disability? Which is essentially meaning, are you incapable of working again? And that is why that CPP disability test is similar to the long-term disability test when the change of definition date approaches in terms of can you perform any occupation. And that is when insurance companies will ask you to apply for it. Again, at Kotak Law, we are often asked, should I apply for CPP disability benefits? The short answer is yes. The reason is because we have had numerous disability insurers argue that when an individual who is claiming disability benefits does not apply for CPP disability benefits, the insurance company raises a negative inference from that. They will then say, if you are not applying for CPP disability, that means that even you believe you are capable of working in some other capacity. Otherwise, why would you not apply for this? And they will then use that against you. As I mentioned, they can also estimate the amount and deduct it from what they pay you, and they will do that, so you might as well apply for it if they're going to try to deduct that from what they have to pay you in any event. If you are ever denied short-term or long-term disability benefits, please give us a call here at Kotak Personal Injury and Disability Law because we offer free consultations and we'd be happy to speak with you about your options. Thank you for taking the time to listen, and I hope this has been informative.